The Money Show. Personal finance.
Warren Ingram is our personal finance guy. He is a personal financial advisor. He's executive director at Galileo Capital. And now this is a really important story. And I need you to listen to the detail of this very, very closely because it could affect you. And first, I must give you a disclaimer because I do know half of tonight's story. And I know half of tonight's story because this is a case that affects family members of mine. So I'm not going to name companies. I don't want to be shaming anybody this evening. I think it's more of a cautionary tale and also an educational tale as to what you can do to protect yourself and beneficiaries of your will, if that is your intention, and also the importance of making sure that your will is absolutely up to date and that people who are named in that will or not named in that will are kept appraised of that particular fact throughout their lives. So here's the story as I understand it. And the details I share do involve family members of mine. About 10 years ago, there or thereabouts, a cousin of mine and her husband divorced. And he died suddenly about 2 years ago, and he left a will. And in that, he left his assets to his now adult children. Included in those assets were some retirement annuities, and they were both named as beneficiaries, not only in the will, but also in the documentation of the retirement annuities. One of the companies that had a retirement annuity paid up, and the kids got their money 50-50. The other decided that it wouldn't be doing so. It apportioned 4% of the retirement annuity to the adult daughter, and it gave 96% to the woman who was living with the ex-husband at the time. And she'd been living with him for 4 years, and she had petitioned, I assume, the insurance company and said, hold on a second, but, I believe I'm due this particular money. And the trustees of the retirement annuity agreed with her, and they've proposed giving her 96% of the money. The adult children, of course, are saying, hold on a second, but we are named as beneficiaries. We're named as beneficiaries in the will. Warren Ingram, personal financial advisor. How unusual is the state of affairs where beneficiaries might not actually be beneficiaries?
It's actually much more normal than we would like to think. It's. When you and I were chatting about this in preparation, I decided to speak to a few trustees of retirement funds to see how what their experience is, and for my sins, I was one of those trustees. I actually did it as a volunteer service to learn a bit a few years ago, and I think it's one of those things when you tell someone you're gonna start your RA and you're gonna nominate your beneficiaries, and and 20 years later, some arbitrary people that you've never met in your life who frankly have never understood anything about you are going to have to decide whether they're going to follow your wishes or they're going to give your money to someone else. It sounds outrageous on the surface, but actually, there's a whole law around this, called the Pension Funds Act, and it actually puts the obligation on the trustees of these pension funds. And when I say pension funds, that includes retirement annuities, provident funds, and the like. Then the obligation is on them to make sure that they look after the person who's died. They actually look after their dependents. And it's quite clear in the law actually to say that could mean and might well mean that you disregard the wishes of the person whose money it was, of the retirement fund member.
It does seem obscene, though. I mean, in this particular case, I don't know the man's wishes. I don't know the man's intentions, but he did have a will in which the children were named as beneficiaries, and he did have them listed as beneficiaries on this particular retirement annuity. But he had in the interim also been living with a woman who has made a claim and could be successful in this particular claim on the basis that she, while of independent means, was to some degree, I suppose, dependent on him as her live-in partner.
Yeah, and so the obligation of the trustees when they do this is the way it works is they will say they will start with looking at who the beneficiaries were, and they will ask them for quite a lot of information around their current financial position. They want to understand what those beneficiaries, what their financial means are, and their ability to generate an income. and then they will actually do an investigation to understand, what was the person, did the person have any other dependents? And dependence is quite a wide thing. So it could well be, for example, a child from another marriage that wasn't disclosed to anybody, and so it's up to the trustees to try and find the current dependents, but also people who could in future become dependent on the person who's died.
Now that's I think an important point here, because one of the arguments I'm told that has been made is that these are young adults with their entire careers in front of them, whereas the person who was living with the deceased, I've got to be careful with the language I use here, but living with the deceased is somebody who would be close to retirement and at some point in the future could probably do with the income when she's unable to perhaps work anymore. And so the trustees would then be taking that into consideration. But it still flies in the face of your wishes as an adult human being who makes a decision and doesn't change your will. You don't change your last will and testament and the beneficiaries on your documentation. It just seems slightly obscure.
And I think the critical point here is that the will actually has zero impact on this whole discussion. So the starting point is who did you nominate as beneficiaries on the retirement, and that's a very good point then that you're making, is that you need to make sure you keep that up to date, because that does have meaning. It certainly, if there were no other financial dependents, then the trustees would gladly, I think, because they don't want to get into a mess in a messy situation, as the one you're describing. They want to actually try and make this as seamless as possible. So in their lives, the ideal is they do an investigation. There are no financial dependents. They follow who's nominated on the beneficiary form, and off they go. But the will doesn't really play much of a role there. The beneficiary nomination is much more important. The will could be some sort of a supporting document to that, but the point will be from their perspective is they need to make a judgment on who. So let's use this example that you're talking about. The person is living with them. On the surface of it, they might seem financially of means, but when the trustees do an investigation, they realize, well, this person is now going to lose out, because there were actually two sets of income that they would have been living on together in a house, and now suddenly there will not be one set of income. There won't be one pension that will be paid out. And only, so in this situation, the lady might be in a position where their joint planning is no longer. And it doesn't require, for example, a legal status. In other words, there doesn't need to be a contract between them. It doesn't need to be that they're married or engaged. She just needs to show the trustees that she was either already a financial dependent or potentially a future dependent. Obviously, the trustees need to apply their minds to this. They can't just take her information at face value. They would require a lot of supporting documentation, both about the current situation and how she thinks it unfolds in the future. That needs to be supported and investigated.
The point is that this is a well-trodden path, I think, is the point you're making. And it comes down to, again, this was a sudden death. The man was outwardly physically healthy and had a terrible heart attack and died. And goodness knows what his intentions were. And that's, again, a critical lesson for all of us, I suppose, in terms of being absolutely crystal clear about whom we wish our beneficiaries to be, and how we wish our assets to be apportioned once we're no longer there to do it ourselves.
Yeah. I think it's a great point. And then there is that sort of just nagging concern at the back of one's mind that if you have a pension fund, provident fund, or an RA, that there are a group of trustees that that might decide against your wishes, even if you've been extremely clear. And so that's the part that, for me, when I look at the story, that's always a bit uncomfortable, because ultimately these are trustees, and if it's a big retirement fund, they might be making a large number of decisions in a day, because they don't meet every day. They don't, they would have, regular trustee meetings, but they'll be appraising themselves of this situation quite a bit on quite a number of people. So and especially in a situation like this where you've got one company that's followed the wishes of the person who's died and paid out to the beneficiaries, and another company coming to a very different decision. And there, my suggestion to everybody is, if you knew you were a nominated beneficiary and you haven't been paid out in the right proportion, and it seems unfair, you have quite a few steps that you can follow to kind of argue this process. The trustee's decision isn't just a final thing. And so the first thing that you need to do is actually lodge an objection with the trustees. And I think what's interesting about that is that they will then need to refocus on the situation, and hopefully they look at it as now a much rarer number. There'll be many fewer people that will be objecting, and one hopes that they come to the right decision if you felt that they were wrong. But if they don't come to a different decision, you can still take it further. And there's this office called the Pension Funds Adjudicator, and this used to be kind of like the public protector of pension funds in the past, where they were quite famous for a while for finding against the big retirement funds when the retirement funds used to behave quite badly, and so certainly that's a route to follow, and then you can still go to the Financial Services Tribunal, and lastly to court. So I think you don't really want to go to court because that's obviously going to cost you money, but certainly that's the kind of route to follow, and I would suggest that in this situation. It seems crazy to me that two boards of trustees would come to such differing views. You would think maybe at the margin they'd be a bit different, but not almost 100% different.
Yeah, it is. It's 96% different in this particular case. I mean, is it, and this is more of a legal question perhaps, and I mean, if you don't know the answer, I'd love a lawyer who understands wills in this particular case. But could I stipulate in my will, if I was in a cohabitation arrangement with somebody, I had children, adult children who were no longer directly dependent upon me, and I was, a little bit concerned about what my partner might do in the event of my early expiry after I'd eaten the mushrooms or whatever the case might be. Could I stipulate in my will saying, this person is actually not entitled to anything from my estate? It is my wish and my desire and my plan that my children, although they've both in the last 2 months each independently won the lottery and are independently wealthy, they're absolutely fine. I want them to have the money. I worked hard for this money for them. I do not want this person to have the money. Could the trustees still go against that if they determined that the person was in fact likely to be dependent on their partner into the future?
I think that there would be a fairly good argument, and as you say, I'm not a lawyer, but I think there would be a fairly good argument that if the person can prove that they were a financial dependent, or in future would be a financial dependent, that they would have a good case to argue. And my sort of initial instinctive response in this is not to rely on a will, but rather actually on a cohabitation agreement between the two of you. Get a lawyer to actually help you draft an agreement. Almost like an anti-nuptial agreement. Before you get married, do the same on a cohabitation to very clearly say between the two of you that we're not financially dependent. We have no claim on each other's current assets or future assets, or any financial liability for each other. Because I think that would be a bit stronger than just a will. Where you lay out a set of wishes, because that's not what the trustees must look at. They must look at, was the person financially dependent on you?
And again, this is quite encouraging, I suppose, for people who fall in love later in life. And there's lots. There may, and this not in this particular case, but in cases generally where, in wealthy families where there may be a younger spouse or a healthier spouse, and they go into an arrangement, into a relationship, and it's lots of love and moonlight and roses, and the person dies, and the kids come in and say, right, time to move out the house, let's go. Your time with our father, mother is past, and you're out of here. There is an element of protection there for people who do cohabit, which I suppose many people will take comfort from, that there is a process in place that also does offer that protection.
True, and I think when I spent that year as a trustee, what I realized as well is there are a lot of financial literacy is a big problem in South Africa. And forget about financial literacy. Just in general, literacy is a big issue, and education standards are a big problem. So when you've got, for example, people who are members of a retirement fund because they are farm laborers of a large farming organization, and they're in a relationship together, but with no marriage. They don't have a formal acknowledgement of their status together, and then one partner dies, and there's potentially a child, for example, that's now financial dependent. It does give some rights then both to the mother of the child and the child themselves. So to me, something that can seem pretty cut and dried on the surface, either fair or unfair, when you understand our country is quite a complex, set of different cultures and economic status and education status, you realize that trustees do have an obligation to apply their minds for those that potentially would never be in a position to argue their case. If you're 2 years old and your dad's died and he never married your mom and he has another family in a different city, those are big issues, and I have a lot of sympathy for trustees in a situation like that.
Warren Ingram, thank you. Warren Ingram is a personal financial advisor, executive director at Galileo Capital. Really testing for families who are left behind, and painful and hurtful. But at the same time, the trustee's role there, as Warren explains it, is one to consider all aspects. It was brand new to me, this particular problem. I was under the impression that once you nominated your beneficiaries, it was not necessarily set in stone, but at least sandstone or limestone or something fairly robust.